purpose of this has been turned upside down. It is being used by the elites for crimes that are damaging our economy and our polity, and never used, like in the U.S., for minor crimes or crimes that are usually committed by the lower classes. Of course, that must be seen in the nature of the character of our criminal justice system. Because if you look at China, whenever an elite commits an offense that they consider damaging to the economy of the polity, they don't waste time. The man is executed. I remember even when I was a young lecturer and I was doing research, I found out for a lecturer who just changes marks for a student, got 25-year jail term in China, or a doctor who gave a fake sick leave to a worker, he got 25-year jail term. So they are serious about offenses that affect the polity or that affect the economy. Even if
Professor Dr. Allow me come in here. Hello, can you get... All right, good. I wanted us to situate it because now you have told us, giving us some kind of meaning and rationale behind plea bargaining, and now we're already, having it in our judicial system. But the crux of the matter is the application here in Nigeria. Have we done well with it? And where have we erred if we haven't?
That is what I'm trying to get to. That we have not done well at all. I pointed out that it is being used for elite offenses. Offenses committed by those of power, by those of social and economic means. And that was not the purpose or the rationale from where we are copying it. And I told you it's related to the character of our criminal justice system. Our criminal justice system, in other words, you should simply bargaining here as being applied in Nigeria in the context of that character of our criminal justice system. There are three things you should note. One is that technicalities are emphasized over and above substantive justice. Take the case of the famous case of Femi Fani-Kayode, who was accused of some corrupt practices, and when they got to court, they argued that the paper brought from the bank is not written in a ledger, and therefore it's not acceptable. And on that basis, the thing was thrown out at that point in time. So it is only those who have the power and the means that are benefited. And secondly, the character of our system of our criminal justice system goes to support the position that all professions are a conspiracy against the population. All this masquerade dressing of judges, all these their gowns, part of the paraphernalia and ritual of deceit. Our people originally are used to knowing about justice, knowing what is right, what is wrong. But the emphasis now is on technicality. So up to now, it has been inappropriately applied. But again, in line with our lopsided criminal justice. And I must say here, I watched your program yesterday. There was one lawyer who put on one, Mr. Akiri was wearing a suit, I think, on your program, justifying Justice Kalba's discretion and blaming the Judicial Service Commission or Judicial Service Council or whatever for what they have done. And I think that I'm really very pleased by Justice Anoma because what she has done is take the first step in a million steps that we need to clear up our judiciary. And I would like to use this opportunity to praise her relative to our predecessors from whatever part of the country that have seen this rot and they have not done anything about it. The fact of the action of that council shows that she's aware of what is wrong, and that starting by getting rid of the abuse of the plea bargaining system in the application of the plea bargaining system in Nigeria is a good place to start. Now, don't get me wrong. it doesn't mean that that plea bargaining is not has no uses. Plea bargaining has uses because, like I told you, it can ease, if properly applied, to get rid of minor cases. It can ease the administrative burden of crowded court dockets. It can reduce the workload of the prosecuting and defense lawyers. It can help law enforcement. For example, if you have a criminal who is able to give you information about other offenders, you can lessen the charge, you can lessen the sentence, and you can even allow a lenient judge to look at his case. In other words, it can be used to free the system for attention to more serious cases, like cases of corruption, cases of treason, cases of arson, cases of murder, cases of rape. The problem, however, is that what we are doing in Nigeria is that the offense, the crime for which guilt is acknowledged in open court or bargained is usually incidental to the real crime. Yeah, somebody has stolen 50 billion.
If you can hear me, because some also argue, in fact, that was part of the argument that Mr. Kiri brought up yesterday, that some of the fundamental problems we have is the penal code and the criminal code. And so if that is not addressed, we'll still have a challenge on our hands. And so before I even talked about
can you come again, please? Can you come again?
Part of what he argued yesterday, which is a fundamental point which others have also raised, is the fact that we have the penal code and the criminal code which needs to be addressed or amended, as it were. And if that is not done, you may have a similar case in our hands, and we could be back talking about the same thing again.
My brother, I'm not a lawyer. I'm not learned, but I'm educated. I have an idea of certain differences between penal and criminal code. In fact, when I was listening to that argument, I was amused because one of the advantages of the penal code over the criminal code is the judge has an opportunity to intervene in the framing of the charges, unlike the criminal code. In criminal code jurisdictions, once the charge is brought by the prosecutor, all the judge can do, if it's improperly framed, is to throw it out or strike it out. But in the case of the penal code, the judiciary has the opportunity to intervene and ensure that the charge is properly framed. So what that lawyer was talking about does not hold water. The judge, if he was serious, had the opportunity to talk about under what provision or section you could bring the charge. And in any case, the matter of discretion, he did not give him the maximum sentence. And then the argument that the man has been punished, is returning all he has stolen, does not hold water at all. Every armed robber, if they return what they have stolen, do you still say you are not sending them to jail? Or those who steal goats in the villages, once they return the goat, don't they get punished?
I think
no, I don't want to. Today we are not discussing corruption, so let's leave that out. But what the lawyer Kiri was talking about is part of the problem of the legal profession, emphasizing technicality over substance and the collective interest of the majority.
Just quickly, talking about plea bargaining, where does the discretion of the judge come in terms of plea bargaining? Because the idea that we have is that it's an agreement reached between the prosecutor and the defender, and they've reached the agreement before they present their case before a judge. Is that how it works?
Now, how it's supposed to work? Okay, how it works in Nigeria is different from how it's supposed to work.
No, not how it works in Nigeria. How it works normally. I mean, is that how it works even in other climes?
Yes. Now, one, the bargaining opportunities should be available to all categories of offenders, not only the rich. I repeat, I'm going to itemize about 3 things that should happen. The bargaining opportunities, this plea bargaining, should be available to all categories of offenders, not just the rich. And as I pointed out, I'm having this